tests have been successfully performed with our witnesses. So I'd like to welcome our first hour witnesses. As an individual, Craig Scott, Professor of Law, Osgoode Hall Law School, York University. Canadian Association for Legal Ethics, Professor Richard Devlin, Professor of Law, appearing by way of video conference. And the Advocate Society, Sherry Conlon, Secretary, Executive Committee of the Board of Directors by video conference. So we will move now to the opening comments, and we'll start here in the room with phone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom. You have the choice at the bottom of the hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. For your information, before anybody asks, all tests have been successfully performed with our witnesses. So I'd like to welcome our first hour witnesses. As an individual, Craig Scott, Professor of Law, Osgoode Hall Law School, York University. Canadian Association for Legal Ethics, Professor Richard Devlin, Professor of Law, appearing by way of video conference. And the Advocate Society, Sherry Conlon, Secretary, Executive Committee of the Board of Directors by video conference. So we will move now to the opening comments, and we'll start here in the room with Mr. Professor Scott. Go ahead.
Merci, Monsieur le Président, et bonjour aux membres du...
Thank you, and hello to members of the committee. Given the time available, I'll go directly to my speaking points. It would be a pleasure for me to elaborate on these subjects or any other subject during question period.
Organizing theme is that C-9 falls quite short when it comes to how transparency fits into accountability of the judiciary in the face of reasonable concerns of misconduct. The only decision made public under either the current or the C-9 system is the decision at the final stage, the report of what is now the panel of inquiry and what will be one of the two kinds of hearing panels. In this regard, my central concern for my remarks is how C-9 doesn't disturb the practice of the Canadian Judicial Council, the CJC, of hiding from view two other kinds of decisions and their accompanying reasons. Indeed, C-9 actually increases the level of secrecy of these two decisions. Now, one kind of decision and set of reasons that it's not made public in ordinary course are known as reasons for referral of a complaint to a panel. Under the current system, it's the vice chair or the chair of the Judicial Conduct Committee of the CJC who sends them on to the review panel. Under the C-9, if that's going to continue, it would be the reviewing member who would be doing that. To give you a sense, in a recent CJC proceeding of which I was one complainant, this consisted of 9 tightly reasoned single-spaced pages. The second kind of decision that doesn't get published is known as the report of the review panel. And in the above proceedings in which I was involved, that report was 13 double-spaced pages. So if they're not published, how is that I know what's in them and how long they are? Forgive me, I might be going overboard, but this is where Kafka comes in. So here, let me explain myself. When a review panel finds there's an insufficient basis to send a complaint onto a full hearing panel, currently to a panel of inquiry, the executive director of the CJC sends a letter to each complainant. It purports to give a gist of the review panel's reasonings. That letter can be well or poorly put together. It's not written by the review panel itself. Now, for the complainants, this is the point, the letter is the decision. That is all they have to go on. If they feel the reasoning in the letter does not stand up to some reasonableness standard, then they can seek judicial review in the federal court. Only, of course, after having found a lawyer able to do it for the funds that the complainants are able to scrape up for a judicial review. Thus, it is only through citizen initiative in the form of a judicial review application to the federal court that the above sets of reasons can become public. This happens because the CJC is bound by the rules of judicial review procedure to disclose to the applicants all relevant documents, which then form part of something called the certified tribunal record of the court. Even then, when the matter gets to the pleading stages, the lawyers for the CJC effectively tell the applicants, who were the complainants, you know, the reasons in the letter that you received and that were the basis for you to seek review, forget those. That's not actually the decision. The review panel decision is the decision, and now that you've forced its disclosure, that is what you must now convince the judge is unreasonable. So it is that complainants must go to court to challenge an unreasonable decision before they have access to what the CJC lawyers tell them is actually the decision. As I said, just a little bit of Kafka there. Nothing in C-9 would change this situation. By analogy to the regular court system, it's as if Parliament and the CJC were keeping from prying public eyes the judgment of a motions judge. Here, the reviewing member's reasons are the analogy. And the judgment of a trial judge, here the review panel. With only the judgment of a court of appeal, here the reduced or the full hearing panel, being made public. Open courts and published reasons are how we approach judges judging others. This, of course, includes cases where the impleaded person is partly or wholly successful. But in the regular system, we don't fail to publish a decision because the defense prevailed. But somehow when judges judge judges, it's only when we get to this third, in the new C-9 system, appellate stage, that we can see the reasons. Consider what the situation means in the context of one of the big improvements made by C-9, really big improvements. The inclusion of a wider range of remedies that are available at the review panel stage in the new Section 102 of the Judges Act. But, along the lines of my theme, because the review panel decision stays secret, the public will be little the wiser about exactly why no misconduct was found, if that turns out to be the case, or misconduct was found but characterized in a certain way, why it was of a certain gravity but not enough to go on to a full appeal hearing, and why a particular remedy has been chosen over any of the others in the new, I believe it's Section 102. Now, I'm getting towards the end. With respect to review panel reasons, C-9 goes on to make the matters worse still. You may have had testimony on why it's there. I find it hard to explain why it's there. C-9 bars reduced hearing panels and full hearing panels from considering review panel decisions and reasons. It also bars the full hearing panel from considering the reasons of the reduced hearing panel. I don't really see how that is justifiable. Our judicial system and indeed our entire approach to the rule of law depends on the giving of reasons by the judiciary and the publication of those reasons so that the legal profession, the public scholars and legislators can understand, apply, critique, and reform the law. Excellent. As well, one key way in which judicial reasoning can be relied on to generally produce better results as you go up levels is that each subsequent court has the benefit of factual interpretations and legal analysis of the preceding levels, which they can refer to, discuss, and weave in some integrated fashion into their own judgments, into their own reasoning. With that, Mr. Chair, I will end, as I know I'm coming up to time. There's a number of interconnected arguments. I have some arguments about how we should understand the administrative law of judging judges, and why this has undue secrecy built in for judges. But maybe I can bring those out in the question period. I do have a set of specific recommendations for amendments to sections 97, 103, 111, and 118, and I would suggest adding two new sections, 160 and 161. They're in my written brief, which is not yet available and can't be circulated until it's fully translated, but hopefully that will take place in a couple days.
Thank you, Professor Scott. And I should have said welcome back. I remember when you were here on this side of the table, but welcome back, and it's great. It's great to see you. It's great to see you here again as a witness. Next, we will move to Canadian Association for Legal Ethics, Professor Devlin, Professor of Law.
Good morning, Mr. Chair, and thank you for inviting me to appear as a witness on Bill C-9. My name is Richard Devlin. I'm a professor at Dalhousie Law School in Halifax, Nova Scotia. I'm here as a member of the board of the Canadian Association for Legal Ethics. I served as its founding president and chair of the board for several years. But more particularly, I'm here because in the last couple of years, I've edited 2 books with scholars from around the world on what might be appropriate for complaints and discipline process for judges. And those 2 books are called Regulating Judges and Disciplining Judges. There are 3 key insights that emerged from those 2 books. The first insight is that the design of a complaints and discipline regime for judges is not just a technical project. It is an important act of statecraft that's about allocating power within our community. It requires us to think about the delicate relationship between the executive, the legislature, the judiciary, and the general public. This is often phrased as the who guards the guardians question. The second key theme that comes out of those materials is that there's another question, which is how should we guard the guardians? This requires us to articulate key values or principles that should guide us in the design and the implementation of a complaints and discipline system for judges. Traditionally, 2 key values have been identified. The first being independence, the second being accountability. But what our research indicates is that there are at least 7 other core values that need to be considered. And these values, in addition to independence and accountability, are impartiality, fairness, transparency, representativeness, proportionality, reason justification, and efficiency. So those are the core values that we must sort of measure Bill C-9 against. The third key insight from our research is that the core purpose of a complaints and discipline process for judges is to promote public confidence in the administration of justice. Over the last 2 decades in Canada, there have been a number of high-profile cases that amply demonstrate that the current regime has failed to enhance that public confidence in the administration of justice. And so the purpose of C-9 is to rebuild that confidence. Now, when you review C-9 generally, there are a number of innovations that are very positive and do a very good job of trying to balance these particular values or principles. But today I want to identify 5 core concerns that suggest that we haven't got the right balance of these principles. These are very significant problems that I hope you can be persuaded to address as you work through this legislation. Our first concern is that not enough attention is paid to the rights of complainants. Thereby, we compromise the principles of fairness and transparency. Our second concern is that there's insufficient lay representation in the process, thereby compromising the values of impartiality, independence, and representation. Our third concern relates to reduced hearing panels. We suggest that the composition of reduced hearing panels and its processes may in fact favour the impugned judge and therefore compromise the principles of impartiality, independence, and representativeness. Our fourth concern is that the remedies for misconduct are not sufficiently comprehensive. In particular, they do not include a power to suspend the judge, and therefore it compromises the principles of transparency and proportionality. And fifth, and finally, our concern is with the annual reports. These reports are not adequately tailored to the needs of a modern democratic society. Therefore, we compromise the principles of transparency and accountability. Now, in the question and answer period, I'll be delighted to answer and elaborate on any of these points. But I want to conclude by emphasizing that it has been more than 5 decades, 1971, since there's been a statutory revision of the complaints and discipline process. The role of Canadian judges has changed profoundly in that time. Canadian democracy has changed significantly in that time. And the expectations of the public have changed enormously in that time. It might well be another 50 years before there's another review of the process. Therefore, Bill C-9 is a unique moment. And the Canadian Association of Legal Ethics is delighted to try to help you make Canada develop one of the most comprehensive and persuasive complaints and discipline systems in the world. I look forward to your questions, and thank you.
Thank you, Professor. And finally, from the Advocates Society, Sherry Conlon, Executive Committee of the Board of Directors. You go ahead for 5 minutes.
Thank you, Mr. Chair, for the opportunity to make submissions to the Standing Committee today regarding Bill C-9, an act to amend the Judges Act. My name is Sherry Conlon. I'm a partner at the law firm Stewart McKelvey in Halifax, Nova Scotia, and I am here representing the Advocates Society. The Advocates Society is a national not-for-profit association of litigation counsel with approximately 5,500 members located across Canada. Part of the Advocates Society mission is to promote a fair and accessible justice system in Canada. My submissions to you today will focus on one central point. The Advocates Society is concerned that Bill C-9 does not allow for an adequate amount of court oversight of the CJC's decisions in its judicial conduct process. I will present to you a simple remedy to this concern that we believe will still achieve the government's laudable goals for this reform. The Advocate Society's written submission to the Standing Committee, dated July 18th, 2022, expands on the points that I will make in my presentation today. Overall, the Advocate Society supports amending the Judges Act to reform the CJC's process for reviewing and addressing complaints made against federally appointed judges. We have seen that the current process is susceptible to delay and high costs. These inefficiencies diminish public confidence in the accountability of members of the federal judiciary for their conduct, and we agree they need to be corrected. The Advocate Society also agrees that one principal source of the delay and costs in the current process is that the parties can apply to the federal courts for judicial review at multiple points in the process. Then, parties can avail themselves of several levels of appeal. However, we submit that Bill C-9 overcorrects this problem by replacing the court review process with review mechanisms that are almost entirely internal to the Canadian Judicial Council. Under Bill C-9, parties can only seek leave to appeal the decisions of the appeal panel to the Supreme Court of Canada. This is a concern because there is no right of appeal. Rather, an appeal is only available if the Supreme Court grants leave. The Supreme Court is not an error correction court, and leave is only granted in cases of public importance. Historically, they only grant leave in about 8% of cases per year. This means there is no guarantee that the Supreme Court will grant leave even in a case where the CJC's decision is wrong. And in our respectful submission, all decision makers can get it wrong sometimes. That is the purpose of appeal courts. The Advocate Society is concerned that Bill C-9 creates a legislative scheme in which the Canadian Judicial Council is the investigator, the decision maker, and the appellate authority with respect to allegations of judicial misconduct. External judicial oversight of the CJC's actions and decisions is all but eliminated. The proposed process is concerning because court oversight of administrative actions is fundamental to ensure their legality and their fairness. This undermines security of tenure, which is a critical component of judicial independence. The Advocate Society suggests there is a simple remedy to our concerns. We propose instead that the parties be provided with a right to appeal to the CJC appeal panel's decision to the Federal Court of Appeal instead of the Supreme Court of Canada. Draft language is contained in our submission. I must stress that we believe our proposed amendment will not reintroduce the delay and costs we see with the current process, in which the government is rightly trying to fix. Advocate Society proposal ensures that the CJC's final decision would only be subject to appeal directly to the Federal Court of Appeal. This will eliminate one layer of judicial review, the federal court, and it will eliminate judicial review of interlocutory decisions, which historically have been the primary cause of the delay and expense, while preserving a right of judicial review on the final decision of the CJC's internal process. The Advocate Society believes that the small change that we propose to Bill C-9 strikes the balance between efficiency, public confidence in judicial accountability, and fairness to the parties, all while maintaining judicial independence. Mr. Chair, I would be pleased to answer any questions from the Standing Committee arising from my submissions. Thank you.
Okay, thank you. And now we will move into our question and comment period, and we will begin with Larry Brock. These are 6-minute question and answer times.
Thank you, Mr. Chair, and good morning, witnesses, and I sincerely thank you for your participation in this important study. I do have a limited amount of time, so I will try to balance my questions with all three of you. I certainly have three unique areas that I wanted to discuss, but I wanted to start off with this proposition, and I couldn't agree more. And I'm reviewing a printed summary of Professor Devlin's statement to this committee. And I couldn't agree more with paragraph 3 of that statement, Professor, that the core purpose of a complaint discipline process for judges is to promote public confidence in the administration of justice. So you cited over the last several decades a number of cases that have shaken that public confidence to the core. And that is an area that I pursued last week when the Minister of Justice, David Lametti, appeared before this committee. And I asked him a specific question that, in his view, does he believe that maintaining the objective of maintaining the public confidence in the justice system is in line with the complainant's interests? Is there a balance? And he emphatically stated that he did. He believed that there was a unique balance that Bill C-9 put forth. So I'd like to hear from all three witnesses, starting with you, Professor Devlin, as to your thoughts as to Justice Lametti's commentary and how specifically you would improve the public confidence aspect of Bill C-9.
Thank you very much. I will go directly to... Is it working? Yeah. I'll go directly to Section 87 of the Act. This is the only section in the Act that explicitly addresses the rights of complainants, and it says, the Council shall establish policies respecting the notifying of complainants of any decisions made. That's all that's given to complainants in the process. This is very weak. It's just notice of the decisions made. This means that once a complaint is filed, the complainants are shut out of the process. And this raises fundamental questions around fairness of the process, the transparency of the process, and the requirement for reasoned justification. And so actually we would suggest that there are actually 4 improvements that could be made to the legislation to give greater rights to the complainants and therefore to promote public confidence. The first one is that the complainant should have a right to be informed of the progress of the complaint. Second, they should be given reasons if their complaint is dismissed. If there are hearings, thirdly, or an appeal, they should have a right to participate. And fourthly and finally, they should have a right to request reconsideration of a decision at any stage in the proceedings. This is particularly important if it's dismissed by the screening officer, the reviewing member of the CJC, or the reduced hearing panel. So with respect, I disagree with the Minister that we are promoting public confidence because we're failing to adequately consider the rights of complainants.
Thank you. Moving on to Professor Scott, do you agree with the Minister of Justice commentary with respect to that right balance? And if you do, if you don't, please explain why. I also, in under 3 minutes, want to give you the opportunity to expand on the recommendations that you feel could enhance Bill C-9.
Thank you very much. Ultimately, I don't feel the balance is there. I think the points that have been made by both the other witnesses are good examples of that. What I would add to the picture is that there's another feature of the current practice of the CJC that feeds into this imbalance, which is that complainants are only allowed to send in their complaint, and they're told in a letter that they can keep sending further information if they have it, but into a void. They have no idea what stages the processes are at, etc. The end of the process I was involved in, something that I think does follow from the current rules of the CJC, is that complainants are not allowed to make submissions. That is, they're not allowed to connect facts to arguments about what they see to be the standards in play. I tried it just to see, and was told that there was no duty to consider the submissions. The vice chair who had carriage of the case at that stage did read them, but emphasized he had no duty to do so. I had sent them after the review panel had actually decided internally. I didn't know that because I had no idea what stage the review panel was at. And I'm guessing that the vice chair, whose hands it was back in, realized that there was a bit of an imbalance because something else had happened, which is that a third party, non-complainant, had submitted an argumentative brief to the council that was passed on to the review panel. Complainant's not allowed to do it. A third party having nothing to do with the case was allowed to do so. And I think he probably realized that at minimum he had to read it and say it didn't make any difference to what he was going to do.
Seconds. Yeah. Of the recommendations that you wanted to talk about at some point in this committee, can you highlight one that's most important in 20 seconds or less?
20 seconds, I would say that both for the reasons for referral and for the review panel report, that should be a duty to publish, and the standard should be the council shall make public the reviewing members' written reasons for referral. The council should make public the review panel report, two separate clauses, to the same extent as the council would be obligated to disclose them in order for them to form part of a certified tribunal record in the event of judicial review proceedings. So the point is, we can get these things. We just have to go to court. Why hold them back, force citizens to pay money to see things they can get through a judicial process? Whatever the standards are that you can maybe hold back some of this stuff for reasons of an anonymity or privacy or whatever, they would still apply. But whatever you'd have to give up, Werther JR, you have to give up proactively.
Thank you, Professor Scott. Thank you to all the witnesses. I'm out of time. Thank you, Chair.
Brock, Ms. Dillon for 6 minutes. Oh, okay. Mr. Nakvi.
Thank you very much, Chair. And, I'll pick up on Mr. Brock's line of questioning, and I'll start with you, Professor Devlin. These are indeed unique proceedings when it comes to looking at the conduct of our judiciary. I think all witnesses acknowledged that fact, and they obviously go to the core of ensuring and maintaining, if not, in fact, I would argue, enhancing confidence in our independent judiciary. So there has to be a fair bit of care and balance that needs to be accomplished. Professor Devlin, you feel that C-9 does not accomplishes that balance. Let me give you an opportunity to explain to us how can that balance be accomplished in a way that we do not undermine the independent nature of our judicial system and the independent nature of our judges in particular as individuals.
Yes, thank you very much for that question. You're absolutely right that these are unique proceedings. You're absolutely right that judicial independence is vital, but judicial independence is part of a larger picture of promoting public confidence in the administration of justice, not just public confidence in the independence of the judiciary. So judicial independence is vitally important. But as I said, there are several other key values. I've tried to identify them for you beyond independence. Again, they are accountability. They are impartiality of this process. They are the fairness of this process. You can't have public confidence if there's no real transparency. You can't have real public confidence if there's not sufficient.
Sorry, Mr. Devlin. Maybe he can't. We can't hear you. So, Mr. Nakvi, do you want to move on to an?
Just pause my time for a second.
Sure.
I think there's some serious issues around quality of the sound and the volume as well. I don't know if there's a way we can rectify that before I continue with my line of questioning.
I know the clerk was working on that before we started, and it was, I guess, a little sketchy. But do you want to try and work with Mr. Devlin?
Yes, I will. That's the best we can do so far, Mr. Chair.
Okay. So, Mr. Nakvi, do you want to continue your?
Well, let's see, if, Mr. Devlin, can you try talking a bit and see if we can still hear you? No, we can't.
No voice.
We can't hear you. Sorry.
No voice.
Sorry. So I may have to.
Okay.
No, sorry. So I'm going to continue.
Yeah, go ahead.
Yeah, Mr. Scott, let me pose it the same question to you around the balance. You also felt the balance not reached. If you can very quickly, if you may have a suggestion or two as to how one can accomplish that balance while ensuring that we are not only maintaining but enhancing the independence of our judiciary and judges.
I think my main point would be that I don't see anything about any of the proposals so far that actually compromise the independence of the judiciary. So that would be my first point. What they do is they enhance the other kinds of values that are crucial, including they remind the judiciary that confidence does not come from overly stacked processes and from an undue degree of non-transparency. That actually feeds the lack of confidence that undermines the very basis of the independence of the judiciary. So embracing, say, more secrecy then is actually healthy. Cutting off the relevance of lower decisions by referrals of reasons or review panel decisions, allowing the judge a second kick at the can to have a de novo review panel and calling it a reduced hearing panel. All these things are clearly safeguards of a certain sort for judges, but on their own, without some of what we're suggesting, that produces serious unbalance. One of the final points I would make is that I think two things are going on here. The bill, but also the CJC, is underplaying something called the open court principle, which applies to tribunals as well, and overplaying the independence of the judiciary principle. And they're also doing another move, which is to say, hey, the CJC, we're just an administrative body. We're no different from any other professional regulator. Therefore, anything that's involved in keeping decisions quiet before there's a tribunal decision, what's the harm? That happens in other tribunal contexts. They're not just any regulator. They're responsible for one of the three most important, the third and most important branch of government when it comes to how individuals are affected by judgments of the state.
Thank you.
Mr. Mackley, we'll pause your time for 1 second, but I guess, Mr. Devlin, your microphone was deactivated. You want to try it again? No, we're still not hearing you.
No.
Still not. Okay, I'm told your microphone was deactivated. Okay, well, we'll go ahead, Mr. Nakvi. You've got about a minute.
I've got a minute left. So I want to just pick on one feature that is proposed that I find it unique and interesting. And I'll start with Ms. Conlon first to get her views on this, which is around including laypersons on review committees. I found that very interesting because we do rely on laypersons when we are appointing judges as part of the JAC process, the Judicial Appointments Advisory Committee process, and to now see having laypersons involved in the review of judicial conduct or misconduct is interesting. Ms. Conlon, your thoughts on that? Do you see benefits to adding lay individuals in this review process?
Yes, we do see a benefit to adding lay witnesses involved in the entire process, and it is an improvement from the perspective of the public confidence in the process. And as we've indicated, the Advocate Society supports all of the amendments, including the addition of the lay witness participation, with the sole exception of the external judicial review process.
Okay, great. Thank you. I think my time is up.
Thank you, Mr. Nakvi. Now for 6 minutes, Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and thank you to the witnesses for being with us today for this very important bill. I would like to start with Mr. Scott and speak to possible sanctions. We all know that when there are shortfalls on behalf of a member of the judiciary and the decisions of the CJC, this can make the headlines, and this has an important impact on public trust in our judiciary. There are some advantages that are given in the same, if we think about some legal procedures that were used in order to gain time in the case of Justice Giroir. And then in the end, he left, but he did benefit from some economic advantages with regards to lawyers' fees reimbursed and pension funds. Mr. Scott, do you think that it would be possible to modify this and to make it so that if the judge that is a subject of a complaint is found guilty, that there be economic sanctions, for example, lawyers' fees? The interpreter, sorry, I'm hearing different voices.
It's saying the same headset that I'm using, for sure.
Alors, Monsieur le Président, vous avez...
Mr. Chair, did you pause my time? You suspended you paused my time, I hope. Thank you. Okay, you can tell me when I can start up again. Is it okay? Okay. Mr. Scott, if you could answer that. Thank you, Mr. Fortin. I can see that it would be a possibility to add to Section 102 this idea that there might be a sanction or a suspension of salary, and that this could be part of what can be done by the panel, by the review panel. As for, and in fact, in Ontario, we've just seen 3 or 4 years ago, there was a process with Justice Isabelle where he was sanctioned with a salary reduction for a 2-month period because he had worn a MAGA hat, or he'd put a MAGA hat on his office, in his office desk, and so a what? A MAGA hat, America Great Again, a Trump campaign hat. So in Ontario, it's possible. It's not really clear that it's possible in this case. Perhaps in 102F or G. I'm not sure. Now, as for lawyers' fees, at some point, I think that the system, the CJC, the government has to pay, but at some point, I think that they don't have to pay. And I'm not sure exactly where to trace the line. Yes, exactly. Where is the line here? And maybe percentages, I don't know. But I'm understanding from your testimony that the idea of looking at this, of thinking of economic sanctions is a good idea. Yes, I think it's a good idea. They're not here for some reasons, I imagine. I imagine there was some pushback to that, pushback from judges themselves. I'm not sure. So what would be the impact of this on legal independence? Could we not argue that the fact of having these types of sanctions undermine the independence of judges or the credibility of the judge that comes back on the bench after having been sanctioned economically? Is there an impact there? Yes, there is. And that might be one of the reasons why there was resistance. A small part of the principle of the independence of the judiciary, well, I'm not really sure how to say this in French. It's that it's job security of tenure. So the fact of hitting on one's salary, perhaps it's in the field of this, and a security of tenor, maybe it's easier not to touch this as a possible measure. But the fact that it is done in another jurisdiction, a Canadian jurisdiction in Ontario, it does indicate that perhaps it's not prohibited. I don't think I have a lot of time left, but you said that this happened in Ontario. This has been in place for how long now in Ontario, and were there any challenges to this? Inaudible. So in 30 seconds, Mr. Devlin or Mrs. Collins, perhaps, would it be possible to examine the possibility of including economic sanctions?
I'm not sure if Mr. Devlin's microphone is working.
Mais vous, Madame Collins, il reste quelques secondes. Quelle est votre opinion?
You, Mrs. Collins, because we have a few seconds left.
About 5 seconds left, so maybe very quick, Ms. Conlon.
The Advocate Society would not recommend any changes to include financial sanctions in the legislation.
Well, thank you. Thank you, Mr. Fortin. Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I'm going to appeal once again that we try to figure out what's wrong with this room, because we have periodic problems. It's all kinds of different people who can be heard quite well on Zoom but can't be heard in the room. So there's a technical problem, not with people's equipment, but with this room that keeps recurring. So I just would ask that we look into that. On the topic today, I'd like to ask both Professor Scott and Mr. Devlin, if he's back, about the proposal from Ms. Conlon that we change the appeal process so that it's an appeal to the appeal court rather than to the Supreme Court of Canada, because it seems to me that the reasoning is correct, that there'd be one effective appeal would not add greatly to the process, and the likelihood of a Supreme Court hearing one of these cases is very, very small. So perhaps Professor Scott?
Very quickly, I think it's a very sound recommendation. It replaces, as I understood it, replaces the Supreme Court. It stops at the Federal Court of Appeal. Possible that could be challenged for not having a further level, but anyway, the point is the Supreme Court doesn't give leave except in minor number of cases. Her reasoning is absolutely spot on. I would add one thing. Judicial review is ousted for the judge, but I hope I haven't missed something in the Act that ousts judicial review for complainants, because at the moment that is the only way complainants can really understand what's going on, as I described to you, getting a hold of what the decisions were when a case is dismissed or dealt with and not completely dismissed. So we're only talking about the judge here, the judge going up that stream, not about the complainants. I hope.
Yes, you've raised a bit of doubt for me on that point. Maybe we can go back to Ms. Conlon to get some clarification on that point.
Yes, first of all, my understanding is that if the legislation was redrafted as we propose, which is to have a right of appeal to the Federal Court of Appeal, there would still be an opportunity for leave to appeal to the Supreme Court of Canada, at least based on our proposed amendment. And on the second question regarding who it applies to, my reading under Section 137 of the bill indicates that all rights of appeal are, including judicial review, are excluded by the Act, and the final right of appeal from the appeal decision is to seek leave to the Supreme Court of Canada. So I wouldn't see anything in the Act that provides any other right of judicial review to anyone involved in the process. But that's not something we examine specifically. That's my read of the legislation, of the proposed legislation.
Mr. Garrison, we'll just 1 second. Maybe we'll check in with Mr. Devlin. Do you want to see if we can hear you, Mr. Devlin? We don't want to miss the benefit of your... No, we still can't hear you. I know, Mr. Garrison, I know they're working on it, but for whatever reason, we're not we're not getting any audio from Mr. Devlin. So I guess we wouldn't. I'll check in once in a while in between questions, but in the meantime, I would just focus your questions on the two witnesses we can hear from. Go ahead, Mr. Garrison.
Back to Ms. Conlon on the two proposals that Professor Scott put forward on requiring the publishing of reasons for the referral and the report of the review panel. Would you have any comment on that proposal?
No, we don't have any comment beyond what's already contained in our submissions. And as I've indicated, the Advocate Society supports the entirety of Bill C-9, including the restrictions on reasonings, but the public aspect and the involvement of lay participants at the hearing panel, we think, addresses some of the concern in terms of public confidence. So beyond that, we don't have any recommended changes to the proposed legislation.
Professor Scott, I'm not sure how much time I have left. So, Professor Scott.
Yeah, so I've double checked the structure. It's definitely what we're talking about is judge and possibly the pleading officer that in terms of going up out of the system, the right of judicial review is not taken away by complainants. It already exists as part of the broader system, and it certainly is not ousted by C-9. If anybody thought it was, you put in a clause saying it's not ousted. Otherwise, complainants in this are made even worse off than ever. JR is a separate thing. Judicial review is a separate thing from an appeal, and when it usually happens is when a matter is dismissed, and the reasons do not appear adequate in the letters that the complainants receive, and they want to challenge that. And that's currently happens rarely, but it's possible. So that isn't touched by this legislation. I hope, again. I'm looking at Mr. Anderson Gary. and the other thing, the lay point is extremely important. But it also goes to the second kick at the can. The judge gets to say, the review panel don't like it. Within 30 days' notice, I want a reduced full hearing. And what is part of that? They get to swap out a lay person for a lawyer. So the lay person's role is there, but then can be stripped out at the instance of the judge.
Thank you, Mr. Chair.
Thank you, Mr. Garrison. Now we're moving to 5-minute rounds, and we'll start with Mr. Caputo.
Thank you, Mr. Chair, and I appreciate everybody being here. This is a really interesting topic to me. Professor Scott, you and I were speaking, and I opened this up to all of our witnesses, and through you, Mr. Chair, I was speaking with Professor Scott earlier, and we're talking about transparency. Now, throughout this process, I've been thinking about it as in what happens on the provincial level with law societies when a lawyer is getting sanctioned. I'm mindful of the fact that we are federal, these are provincial, but certainly an analogy can be drawn. And I believe in British Columbia and likely in most jurisdictions, when a complaint is made and that complaint is deemed not to be frivolous or spurious, that complaint is automatically made public. Now, Professor Scott and any of the other witnesses, can you comment on Bill C-9 and you know, the analogy or lack thereof in this legislation to that transparency?
On the specific example of the complaint being made public, it is not made public by the CJC, but the CJC current rules, the current act, and this new act, revised act, doesn't prohibit the complainants from making it public. But it's not part of the system to make it public. So I'd leave it at that, because the other aspects I'm particularly concerned about, which is what then is done with the complaint, are also not made public, and that's my concern.
Right. And before I hear from the other witnesses on this point, may I just ask you a follow-up? Is that a concern to you when it comes to transparency? And I'm mindful of the fact you say a complainant can make it public. I mean, anybody can make anything public theoretically, right? But coming through the official channel is a decision being released. Does that concern you when it comes to transparency?
Well, it does, but again, it's less the complaint not being made public than how it's handled, and the fact that the only way you can make public the reasons for referral or the review panel report is to go to court with a judicial review application. It's got things backwards because it says the public has a right to this, but you have to go to these extra steps, pay money to do it. Why not do it proactively?
Yes, and that's part of the transparency. So if I understand your point, this is a small part of a bigger problem when it comes to transparency.
Yes.
Okay. Thank you. I'm not sure if Ms. Cross wants to weigh in on this here, please, or do we have our other witness present back, Professor Devlin?
I can weigh in simply from the perspective of the Law Society. I can speak to the Nova Scotia Law Society, and it's actually, Bill C-9 is quite consistent in that complaints that are filed are not made public, and it's only when the matter is referred for a hearing and charges are laid that it becomes public. Everything up to that level from a lawyer's perspective and the complainant's perspective is kept private, and I would see Bill C-9 as being consistent with that process.
Interesting. I believe in British Columbia, once the complaint is found to be, I don't want to say meritorious or having some potential, non-frivolous, then it is made public. But my understanding is that Bill C-9 wouldn't make it public at that point. But I might be mistaken.
Yes, and so just to clarify, it obviously varies by jurisdiction, but in Nova Scotia, it depends on whether it gives rise to professional misconduct or professional incompetence, and charges are laid, and at that point it becomes public. But there can be breaches from an ethical perspective that do not give rise to professional misconduct or professional incompetence, and those are not made public, including the disposition. And so that is why I said I felt that Bill C-9 is consistent with that approach, because a similar approach is being taken.
Have any thoughts on that?
Perhaps. Is my volume? Can you people hear me now?
Yes.
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 Yes. So
yes.
Go ahead. Yes. So thank you for that. I apologize for the technology problems. Not sure it's my fault, but anyways. So I agree with Ms. Conlon and her description of Nova Scotia. I'm not sure the analogy to the regulation of judges is the appropriate analogy. The function of law societies is to promote the public interest and practice of law. And just because they don't necessarily make their processes transparent is not necessarily the reason why the CJC should not make its processes transparent. So I think, again, if we're trying to think about the larger values we're trying to promote, there's also significant public dissatisfaction and lack of public confidence in how law societies regulate also. So I'm not sure an awful lot of light is captured by sort of looking to, well, what do law societies do in this regard? And could I just take a quick second to just respond to the previous question around the judicial review question? And that is that
you have 30 seconds, and I'm fine with you taking that time. Thank you.
And basically, it simply said that we agree with the Advocate Society that appeal to the Federal Court of Appeal would be a good move. The only clarification I would make, though, is there's a nuance in this, because if you look carefully at Section 146 sub 2, which deals with the fees that are paid, it says no payments to lawyers representing a judge are to be made in respect of any judicial review of any decision made under this division. And this seems to acknowledge that perhaps, in fact, there could still be a judicial review process. So I think the legislation tries to exclude the possibility of judicial review. I think they're also implicitly acknowledging that it still could happen through this process, because maybe given the Federal Court of Appeal's decisions in recent years, they're saying the Canadian Judicial Council cannot exclude judicial review. So that's a nuance. But basically, we're in support of the position advanced by the Advocate Society. I'll stop there.
Okay, and finally, Madam Diab.
Thank you very much, Mr. Chair. And listen, I've got two out of 3 witnesses on this panel from my own home province. So nice to see you, Ms. Conlon and Professor Devlin.
I was born in Windsor,
Oh, you were
Windsor,
born
Nova
in Windsor,
Scotia.
Nova Scotia.
And-
Well, 100%. Could that be a better morning for me?
In the same hospital as Scott Bryson and Jeff Regan.
Probably my hospital then. No, just kidding. So welcome, and Professor Devlin, I'm glad that the audio is working for you. You seem to be a bit of a celebrity here. I think a number of the panelists here or people in the room said you've taught them, so I know you started at Dalhousie the year before I left, so nice to see you. I want to go back to a really simple question, I guess, and maybe I'll start with you, Ms. Conlon. What is it that the government is trying to address by bringing in Bill C-9? And I do hear that, you pretty much support what the recommendations are, with the exception of, one issue having it go to federal court. But can you take me back to sort of, in your opinion, what is it that we're trying to address? And is there anything else other than, and I suppose you're limited in your testimony because you've only looked at it so far, but is there anything else you'd like to share with us on for our benefit in our review here?
Thank you for that question. We would see this as being 2 fundamental objectives. One is to increase the public confidence in the judiciary. And 2, and there can be tension between the first and the second, which is maintaining the independence of the judiciary, and particularly security of tenure. And that is why the Advocate Society thinks that this legislation strikes the right balance between the 2. It does a number of things. It streamlines the process. It reduces the time and the cost and abuses of those that have occurred in the past. It increases lay participation, and our only concern, and this goes to both security of tenure of judges as well as public confidence in the process, is the external judicial oversight process. Otherwise, in practical reality, what we have is a piece of legislation that allows the entire process to be conducted internally by the CJC without external judicial oversight. And I understand the argument that the appeal panel within the CJC is comprised of judges sitting as an appeal court. However, they are performing an administrative function pursuant to the Act, which is different from the judicial function in an appeal, which we would propose to be the Federal Court of Appeal. And as I've indicated, the concern for both public confidence and security of tenure is that there be adequate external judicial oversight, and that is, we are concerned is not accomplished by the current piece of legislation, because in the vast majority of cases, it is likely that the Supreme Court of Canada will deny leave because it does not meet the public importance test that's been set out by the Supreme Court of Canada, and there will be little to no testing by way of an appeal.
So thank you, Ms. Conlon. Mr. Scott, I like how you described it, judging the judges. And again, here we're talking about federally appointed judges. So I'm not sure which of you have practiced law in terms of going to court. I guess my question is, what types of complaints, or what are the complaints that could be coming against federally appointed judges? Is it the fact that maybe complainants that we don't like the decision, or does it go more to societal issues and so on? I can remember when I started, actually when I articled back in the late 80s, early 90s, my goodness, most of them were male judges, and I tell you, there were horror stories in courtrooms from females. But I'm just wondering, I don't know if any of you can comment on that, because I would be interested to hear that, and I don't know who to ask that question to.
I can just say something very briefly. I think Ms. Conlon probably has more direct experience, but it runs the gamut. The CJC does see an awful lot of complaints that do get screened out, because really what they are is people who don't like what a judge decided, and they throw into it a little bit the judge's manner or tone or whatever, that kind of stuff. So there is a distinct need for a screening mechanism because things that are really not in its purview do come up a lot to the judicial councils. Beyond that, it can be individual conduct of judges, so sexual misconduct or whatever, so there's actually a victim, not just a sort of a complainant in a general public interest sense. There can be interference in lobbying, which I believe has occurred recently by one judge, but the review panel did not agree that that was the correct characterization. There's a whole range of things that can throw the integrity of the judiciary into doubt.
Thank you, Madam.
Thank you very much.
Thank you to all of our witnesses, and it's unfortunate we had some technical difficulties, but I think everyone would agree we heard some really important and thoughtful testimony. So we're going to suspend for 2 minutes. We have another panel of witnesses to get set up, and we will get started as quickly as possible. Thank you to all of our witnesses.
Thank you.
Thank you.
Performing myself those duties. Ms. Corrado's role as Senior Counsel and Secretariat is focused on the judicial conduct process, and she or I will be pleased to provide answers to your questions later. Mr. Chair, before I turn it over to Ms. Corrado, allow me to make a few observations about the Canadian Judicial Council. Le Conseil est présidé par le juge en chef.
The Council is chaired by the Chief Justice of Canada and is composed of all Chief Justices and Associate Chief Justices in the country, that is, those of the Courts of Appeal and Superior Trial Courts. At present, there are 44 such positions of Chief Justices and Associate Chief Justices. Under Section 60 of the Judges Act, the Council's mandate is to promote efficiency and uniformity and to improve the quality of judicial service in superior courts. As you know, the main functions of the Council are focused on judicial conduct and judicial education. That being said, the Council has several committees working on different subjects.
On a variety of fronts, including, for example, ensuring court services during the COVID pandemic through, amongst other things, the Action Committee on court operations in response to COVID-19, co-chaired by the Chief Justice and the Minister of Justice. The Council has signed MOUs with the government on judicial education and the Council's governance. It has published represented litigants and has ensured more communications and publications in order to increase the transparency of its work. One last example of Council's recent work is the new and revised ethical principles for judges that Council adopted and has published on its website. These revised principles are founded in the concepts of integrity, independence, equality, diligence, and impartiality, and they recognize that ethical considerations evolve and need to keep pace with society's expectations. Now, Mr. Chair, I feel this may be a good segue to pass it over to Ms. Corrado, if you agree.
Thank you. Thank you, Commissioner, and thank you again, honorable members of Parliament, for your invitation to speak on Bill C-9. This is something that the Canadian Judicial Council has indeed been looking forward to, and you will know that the Chief Justice of Canada, as Chair of Council, has spoken publicly on a few occasions on the need to bring this reform in order to bring more efficiency and transparency to the judicial conduct process for the benefit of all Canadians. As already indicated, the Council has also worked on the proposed reform with the Department of Justice and the Canadian Superior Court Judges Association, and we look forward to the adoption of Bill C-9. As you know, Section 99 of the Constitution Act 1867 provides for the security of tenure of judges, which is a key element of judicial independence. A judge of a superior court can only be removed from office by the Governor General on address of the Senate and the House of Commons. Judicial independence means that judges must be free to decide independently from any form of direct or indirect coercion. However, judicial independence does not require that the conduct of judges be immune from inquiry. On the contrary, as stated by Section 99 of the Constitution Act 1867, a superior court judge shall remain in office during good behavior. Therefore, an appropriate system for the review of judicial conduct is crucial to maintain public confidence in the judiciary. It is from this standpoint that the Canadian Judicial Council was created. Council is the only body mandated to determine when the obligation of good behavior under Section 99 of the Constitution has been violated, as well as which type of misconduct is serious enough to merit the removal of a judge. Ce ne sont certainement pas toutes les plaintes qui justifient.
All complaints do not justify a recommendation of revocation. The majority of complaints received by the Council are not the jurisdiction of the Council or are unfounded, oftentimes because they're not linked to judicial conduct, but a decision made by the judge. So this brings me to speak to the current process and what C-9 will allow to improve and reform.
A full judicial conduct review process is composed of 5 stages within Council. The first two stages, have been qualified by the courts as a screening stage. The third stage of the process is a review panel that will decide whether an inquiry panel needs to be created if the complaint is serious enough to merit removal of a judge. Under Bill C-9, the review panel will also have other tools. It will be able to impose other types of remedy for misconduct, such as private or public apologies, counselor, or continuing education for the complaints that fall short of removal. The fourth level of the process is an inquiry panel that makes findings of fact and may recommend removal of the judge. If the inquiry panel recommends removal, then we move to the last stage of the process, where a minimum of 17 members of Council must consider the inquiry report and recommendation for removal. Under Bill C-9, if a review panel refers the complaint to a hearing panel, and if the hearing panel recommends removal, the judge will be able to appeal that decision within Council. Bill C-9 provides for this appeal mechanism so that Council will deal with any appeal application in a more expeditious manner, and Council as the appropriate authority and guardian of judicial conduct. One obvious improvement that Bill C-9 brings is efficiency of the whole process. Over the past years, we have witnessed how the current process may allow for lengthy delays due to multiple judicial reviews. Overall, we agree that Bill C-9 aims to strike the right balance of fairness for both judges and complainants in order to maintain public confidence in the conduct review process. And we also agree that it aims to strike the right balance between accountability and judicial independence. Le Conseil espère que les projets de loi C-9.
We hope that C-9 will be passed very soon. We are convinced that these changes will have a significant and positive impact on the process and on the conduct of the judiciary, and this is to the advantage of all Canadians.
Council's views and for your excellent work.
Okay, thank you to you both for your testimony, and now we'll move into the question and answer period. These are 6-minute rounds, beginning with Mr. Van Popta.
Good. Thank you, Chair. Thank you, witnesses, for being here. This is a very important study. We're studying judges judging judges. And at this committee, we've heard testimonies on previous studies, one particularly on the victims of crime and another on the defense of extreme intoxication. We're hearing from witnesses who feel that the justice system isn't very just to them. We heard one executive director of an abused women's center say that if this defense of extreme intoxication becomes permanent, as women, we've got the message loud and clear that we are not safe in Canada. Now, whether or not that position is justified, it is a commonly held understanding or perception of the justice system. So now moving on to the functionality of the C-9 and the functionality of the Canadian judicial system. There's the case of Quebec Superior Court Justice Michel Girouard, and he's fighting the Canadian Judicial Council's recommendation that he be removed, and it's gone through appeal and appeal and appeal. It's dragged on for years. And again, right, this puts the Canadian judicial system in a bad light in the eyes of the public. So how does C-9, this is for you, Ms. Corrado, how does C-9 improve the public perception of how justice is administered in Canada?
Thank you. So with the case of Giroir, and now it's been done, he has resigned, and he lost the application for appeal to the Supreme Court, but it was indeed a case that dragged on. There were multiple judicial reviews, and this created costs and delays. And this is what Bill C-9 aims to correct that no more judicial reviews of this kind will drag on forever. Right now, the process and what was done in Giroir is that every decision of counsel was was brought to the federal court for judicial review. And that creates a long delay. With Bill C-9, there's going to be an appeal mechanism. There's a privacy clause that doesn't allow for those judicial reviews anymore. And in that context, it provides the balance of procedural fairness for the judge to contest a decision of counsel. And it also provides for counsel to streamline. And I think Minister Lametti gave a good example that the process keeps going up instead of going sideways with multiple judicial reviews that create undue delays.
Good, thank you. Now, an earlier witness that we had here today, Ms. Conlon from the Advocate Society, on that one hand is applauding C-9, saying it is definitely an improvement, but on the other says that building in these efficiencies of no appeals, or only internal appeals, was an overreaction. And their organization is recommending an amendment to C-9 to include the ability or the right to appeal to the Federal Court of Appeal, not to the trial court, but to the Court of Appeal. What are your comments on that? Would that be an improvement that we should consider? Either one, maybe Ms. Corrado. Yeah.
Perhaps I can start if you'll allow me to bring any further information. At the full hearing panel, obviously the Canadian Judicial Council is made up of chief justices, associate chief justices, and when the matter comes before a full hearing panel, it will have two of those members on the panel. It will have a member of the association or nominated or at least recommended by the association as well. We'll have a lay member, and we'll have a lawyer that has been nominated by the Minister of Justice. So in light of that makeup and of that panel, we are of the view that the appropriate body to review such a decision would be the Supreme Court of Canada, to review a decision of the Canadian Judicial Council and that particular hearing panel.
So I just wanted to interact with that. So that question was put to Ms. Conlon, and she said that their proposal does not exclude the ability to appeal from the Federal Court of Appeal to the Supreme Court of Canada, but that's always a leave application, and most leave applications are denied by the Supreme Court. And so then she thought it would be fair that there be a right to appeal to the Federal Court. Your comments on that?
I don't know that I have further comment to add, other than that I respect the view of the Advocate Society in making that recommendation to you, but we still are of the view that the appropriate body to review a decision of a full hearing panel and of counsel would be the Supreme Court of Canada.
Thank you.
I would also add that that proposal would add another layer, and this is what Bill C-9 is trying to cut, all the delays that is basically relitigating and re-bringing forward those comments from the judge or those procedures from the judge. So, I respect the proposal, but it would add another layer which is counterproductive to what Bill C-9 is trying to do.
Thank you.
10 seconds.
Thank you. Back to the chair. Thank you.
Thank you, Mr. Van Popta. So, Madam Diab.
Thank you very much, and thank you to both of you for appearing today. In your opening statement, you said there's 44 positions. So we're talking about federally appointed judges. I would like to go back to the question that I asked earlier. What are the types of complaints that we are receiving today? And I guess the question is, the people that are complaining, I'd like to know sort of what it's about and how difficult is it for them in terms of cost. I guess one aspect would be we're trying to streamline the process to reduce time and make it more efficient, but also safeguarding the impartiality and independence of judges, which is so important. But on the other hand, I guess if we look at the last number of decades, what are what kind of complaints do we receive?
I'll start and ask Ms. Carrado to follow up as required. There are more complaints that are made nowadays than in past years, and that is not surprising in light of people being more informed about their rights, having access to various information, and there are more judges as well. So last year there were over 600 complaints. The majority of those are may be excluded or dismissed by the executive director. The reason for that is that many of those are often related to matters that should be appealed and are not related to the conduct of the judge. Those are a lot of these cases, and a lot of these cases as well, or complaints I should say, are in the area of family law, where passions are high. Issues of access to children is obviously a very sensitive area, and people may well be very upset with any decision that may be rendered that does not please them. So. And some other complaints are simply frivolous or illegible. We receive some anonymous complaints as well. And those that make their way up to a member of the conduct committee and then to a panel and ultimately to what exists now as an inquiry panel are obviously some very concerning issues for the council. Council takes great pride in ensuring that the judiciary across Canada can be respected, that public confidence in the judiciary is maintained, and so takes very seriously any complaint that may raise issues about that public confidence. There are not a lot of them, but they certainly make more headlines than others, and that is certainly fair. But I guess what the point I'm trying to make is that these are standalones at the end of the day. The majority of the complaints that we receive, as I said, may often be dismissed at an earlier stage, and you hear more about those standalone issues.
So I appreciate your comments, and I know you were both in the room when the first panel was giving their evidence. Appreciate your comments on the Advocates Society and their recommendation. Can you briefly, with the time that we have, can you tell me, you've also heard from Mr. Scott and his recommendations, and as well as from Professor Devlin from the Canadian Association for Legal Ethics. Can you tell us, your view on those recommendations?
Is there a specific one that you would like us to comment on?
I know there was, there's some that we couldn't even get to because of the timing and the audio and so on, but I guess the couple that you have, that you heard, particularly Professor Devlin was talking about, this seven, that there's so many more values that are so needed to be protected that he feels that they're not in the bill. I mean, generally he's okay with it, but there were a couple of other things that he was concerned about.
You want to speak?
So as per the values, we have the ethical principles that were reviewed very recently and to adapt to the evolution of times and the landscape of the law. And so all those values are included in our ethical principles. Bill C-9 is more about remedies and tools when there is a case that deserves at the attention of counsel. I'll bring you back to my initial comments that security of tenure is something that's protected by the Constitution. So for something that is so protected and important in our society for the democracy of this country, the reasons for removal have to be very serious. Now, the process now needs to be streamlined, and this is what Bill C-9 intends to do. As per other comments that were brought...
How about the specific one about there's not enough attention to the rights of the complainants?
Thank you. I'm glad that you asked that question because currently our procedures provide that a complainant will be advised when the disposition of a complaint is done. So, and we have to remember here that this is a very unique process. And I think there is a confusion about how that process works. This is not a statement of claim that's filed before the court, while the person who files the statement of claim is a party to the proceedings. This is a disciplinary proceeding, and there's a body that's mandated to look at it, and that is counsel. And so counsel has that expertise and that purview to decide what is a violation of Section 99 of the Constitution. So a complainant, when they file a complaint, they are not a party to a proceeding. Counsel will take that on. Counsel's mandate is the search of the truth, and counsel will do inquiries. And there's extensive case law on that regard, on the rights of the complainants and the duty of procedural fairness for them. And just to name a few, there's Slanky from the Supreme Court, from the Federal Court of Appeal, that provides about the transparency and the rights of the complainant because they don't have standing. Subsection 63(2) of the Judges Act does not give standing to complainants. There's also Cosgrove from the Federal Court of Appeal that talks about the publicization and confidentiality of complaints. And there is many more. Unfortunately, I didn't hear any case law this morning being mentioned, but there is extensive case law to that effect. The rights of the complainants are protected. The duty of fairness is protected, and the rights they have are very minimal because we are not in an adversarial mode.
Okay, thank you. And now for 6 minutes, we'll move on to Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. And thank you for being with us here today. This is an important bill, and the opinion of the CJC, of course, is primordial. So we're very, very pleased to have you here. We would have liked not to have to speak about it, but the Giroir case was highly mediatized, and it's probably the same thing for everyone. I cannot challenge the right of judges to appeal a decision or to contest a decision of CJC, but I believe that what people are trying to do is to set forth the process. And there's something that comes forth in public opinion, and is the issue of costs. And we know this, and I don't want to be too specific on the case of the last judge that we have spoken about here, but abuse of procedure does prolong deadlines. This costs a lot with regards to salary, but it has economic consequences with regards to legal fees. And a comment that comes back a lot is that, well, if he was guilty, if the decision was founded, why wouldn't he have to reimburse the legal fees of his lawyers for the process? Well, perhaps yes, perhaps no, perhaps in part, perhaps procedures judged to be frivolous or useless could be subject to a specific charge. Did you examine this possibility on your side? Perhaps Mr. Giroux and then Mrs. Corrado. Yes, you have raised one specific case that reflects the reason why C-9 has become necessary. The multiplicity of requests in this file has made it so that the file lasted almost 7 years with large amounts of legal fees and other costs, and so that the CJC was able to respond. In the bill, I noted that there are some guidelines that are set that make it so that the period during which, or the period that will be taken into account to calculate the pension ends once a recommendation is made by the CJC to the Minister of Justice to revoke this person as a judge. There is no control for legal fees with regards to C-9, and if there was this type of request, legal fees of the judge, or rather, legal fees, yes, of the judge, would not be paid. When we pay legal fees of judges, we do this we have a specific envelope for this reason. We have to ask the government to renew this each year and to award this funding if necessary. And C-9 has taken this into account, and we wouldn't have to repeat the exercise each year. We are tied by the tariffs imposed by the Department of Justice to retain the services of lawyers. And I note that C-9 also refers to the legal fees, the commissariat, and that we have to consider what the government has set out for legal fees, and if we have to not respect this amount, we have to justify why. So if a justice starts a procedure in the context of a sanctions, could the judge not as we do in civil rights, when procedures are judged to be frivolous, that they would have to pay? Well, if I understand your question, is that we would be able to ensure that the judge would not have access to legal fees paid. Yes, or that he would be ordered to reimburse some of the fees. Well, I know that a discussion has been held to see in provincial regimes, for example, and I know that the Department of Justice referred to a decision, the Bourbonnais decision. It was a Federal Court of Appeal that made it so that a judge had to have a right to his legal fees paid when he or she is subject of a complaint. Once again, this is subject to the tariffs that have to be respected. Thank you. Mr. Scott was here before you, and he said that a decision was rendered recently, I believe in Ontario, and a judge was sanctioned. There was an economic sanction imposed on a judge. I think it was two months' salary or something like that, because he had a MAGA hat on his desk during a hearing. Are you aware of this? And what do you think about it? I'm not really aware of the decision. I heard about it through the media. Obviously, one of the main components of the independence of the judiciary, well, there are three main components to this. One, administrative independence. The other, job security, if you will. We're talking about a nomination, but that's what it is, and financial independence. And so, without having analyzed this thoroughly, it would seem to me at first blush that retaining the salary of a judge would go against this principle, one of the three principles of fundamental principles of the independence of the judiciary.
You'll note, colleagues, that the bells are ringing, but we do have a bit of time before the vote, so we'll turn it over to, if that's okay with everybody, we'll turn it over to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. I'm the one that's never okay to proceed when the bells are ringing, and I think we should perhaps enforce that even when it's my own ox that's being gored today. So I would prefer that we adjourn.
Well, we do need unanimous consent to continue, so if we don't
I'm
have
the one
that...
not giving you unanimous consent.
Well, it was good of you to do that before your question and not after. Okay, thank you to our witnesses for appearing today. Very helpful submission, and we will adjourn the meeting and we can go vote. Thank you. Meeting adjourned.
All right, so how the Canadian Judicial Council operates, how transparency does not exist, and how the CJC throws complaints in the garbage and thus perpetuates the corruption and lack of a transparency within the Judicial Council of Canada. So let's find out a little bit about this. So what they are is essentially a group of judges, politicians, and policymakers that are only there to insulate judges from complaints, accountability, and complaints. And there is always what's called a moderator. This moderator is it's sort of the head of the class. So when you go to the Canadian Judicial Council with a complaint, that person throws it in the garbage, gives a lame reason for throwing it in the garbage, like no reason at all, and just says, we're not taking your complaint, and gives you no reason. This then insulates the other judicial council members from even seeing it, so they don't get their hands dirty, right? So this is equivalent to maybe a murderer is hired by a group of people. Money is moved, but the people that hired the murderer don't ever touch the money, and they never see the dead body, and they don't know how it's done. So this Canadian Judicial Council is designed in exactly the same way, where they have a moderator. They know he's doing something really bad. He's part of the Canadian Judicial Council, but his job is to throw complaints in the garbage. And this keeps the hands clean. It keeps the other highly corrupt Canadian Judicial Council members from ever having to touch this. So if there was ever if ever say another entity, and this would have to be Martians because there's no entity in Canada that would ever be able to hold the Canadian Judicial Council to account. But say Martians came in and they made the members testify, they would be able to say, oh, we didn't know anything about this. This is all news to us. Because honestly, they did not get to see the complaint filed by, say, Ben Applegate or the other thousands upon thousands of other complaints that are put in about essentially corrupt judges every single year in Canada that get thrown in the garbage by the Canadian Judicial Council. And of course, the Judicial Canadian Council is the only regulatory body in Canada that is supposed to hold judges to account. There's a couple more little tricks, administrative tricks they do. So you can put in a complaint, but they want you to use this little form here, right? And these forms are actually good if third parties get to also be CC'd on these forms. So what it would do is, if there was a third party, they could see complaints come in, and they would know that, say, 1,000 complaints came in about judges in 2020. They would be aware of that, but it's not how it works. These complaints forms are strictly designed to weed people out. But at the same time, it is good that, laymen that don't know much about how to file a complaint, or maybe forget to put their address in, or the name of the judge in this case, or the type of complaint. It does guide them to some degree, but you can see here it has a 2 megabyte limit, the file that you can upload the proof. You could also know that our highly, highly corrupt courts do not allow recordings, so you would not be able to put a recording into this complaint and use that as proof. And that's unfortunate. We have one of the most untransparent courts in the world, and I have lots of experience with the courts, all the way from criminal court to youth court to family court, all highly, highly secretive court systems where transparency does not exist. But yeah, so let's see who these are. So we got what we do. There we go. It looks like they may have pulled their picture out. So they don't want you to see that they're all who they are, right? So this, this should, so about, okay, who we are, here we go. So there are 44 members. They all make a ton of money. You gotta know that. So this is members and staff here. So let's zoom in on this, yeah. So here they are. These are the most powerful people in Canada. Pretty scary. So it says here they comprise of chief justices and associate chief justices. And some of these people can honestly, smirk. Well, because they're making over $500,000 a year. They're insulated from people such as I who put in complaints. They're insulated from the atrocities they cause families across this country. A lot of them are just unaware of the horrors they're responsible for and their cover-ups. Now, there are some, and there's probably a good percentage of these are full-on psychopaths, and they just don't care, or they justify their secretiveness, saying that maybe other nations would come in and take over their judicial system or take over their government and do bad things. And this may be true. And I think to a large degree, this is why there's such secrecy and there's such a circling of the wagons within the higher echelons of the Canadian government, which is the Canadian Judicial Council. So there's no difference. I mean, they pretend they're different, but they're not. They're one and the same at the highest end, right? Remember the PMO, the Prime Minister's office, appointed every single one of these people here. So they all have ties to the PMO's office. And then, of course, the PMO's office is a highly secretive place where there's most of the people that do the electing and the policy making can never be voted out of government, right? We vote out the Trudeaus, we vote out the Harpers, we vote out the Polyev or whatever his name is, this new fella. But you never vote these people out. You never are able to hold these people to account in any regard whatsoever. There's zero. It's a closed loop system where they insulate each other. But yeah, so this is the Canadian Judicial Council. Whether they see it or not, they're responsible for essentially the down, the decline of our democracy, decline of what we held as dear to us, our democracy. And one of the pillars of democracy is transparency, accountability, and the ability to even speak to these people, but you can't. These people don't have emails, they don't have phone numbers, they don't have any way of getting a hold of them. You can't even get a hold of their people. So say you had one of these judges in the United States, even, they would have a way of contacting them. Now, they may not be directly contacted, like, say, a member of parliament in Canada. You don't normally talk directly to your member of parliament. You speak to one of their people. They figure it's good enough to bring to the member. They will. Of course, it's all political. If it's something to, in Canada, you actually no longer get to communicate with your MP at all unless it's something they can springboard off of and use to further their own political career. The system has fallen apart, and I do really, really believe that you're seeing the disintegration of trust in our system. And these people, to a large degree, a huge degree, are responsible for that, because the trust is rotting away at the top and it's filtering down to the common people, because we take direction from them. Even the provincial court takes direction, and this is Supreme Court, right? From Supreme Court judges. But some of these may have been provincial court judges in the past, right? But it all filters down. I was recently speaking to a provincial judge, highly dysfunctional, corrupt provincial judge, and he kept quoting federal policy in his highly convoluted reasoning for giving his judgment. And again, his judgment was to seal documents regarding a armed robbery suspect. So it's all judges take direction from the Canadian Judicial Council, which again throws complaints in the garbage and circles the wagons for the elite in Canada.